and welcome to another episode of Law and Sarasota. I'm your host, Adam Tabrouge, and today we're very fortunate to be joined by Sarasota County Court Judge David Denkin. Judge Denkin, welcome to the program.
Thank you, Adam.
Judge Denkin, first I'd like to ask folks who are on this show, what was your motivation in going to law school? What was your journey to the law?
Well, two-part answer. First, I couldn't get into graduate school in psychology, and secondly, I always voted for the underdog, rooted for the underdog, and being a lawyer was a great way to do it. So, took the LSATs.
Where did you go to law school, and how did you like the experience?
Went to law school at Stetson in St. Petersburg. Did it in 2.5 years. It was great.
How did you end up in Sarasota? And tell us about your early career here in Sarasota County.
Well, I was a senior, and like everybody else, we were looking for jobs all over the state, and I was looking at Miami to be a public defender. And one of my professors suggested I speak with one of the prosecutors here in Sarasota, interview for a job here. I did. I liked what I was told. The town was amazing back in '81. It was like a tiny town to me compared to where I grew up, which was Miami. So I took the job.
And tell us a little bit about working as a prosecutor and what kind of cases you handled.
Well, when we're hired as attorneys at the state attorney's office, it hasn't changed since back then, and you start off in misdemeanors. You work there for about a year. Then they transfer you to juvenile to get familiar with felony work. And then you go to felonies. So I did misdemeanors, juvenile, and then felonies.
After you left the state attorney's office, tell us a little bit about your law practice after that.
Started in '81, left in '83, and then all I did was criminal defense work and family law.
And how was it that you became a Sarasota County Court judge?
Well, I applied for openings through the nomination process. I made it up to the governor once. Unfortunately, so did Judge Bonner. Judge Bonner got the appointment. The following year, there was an opening. One of the judges had resigned to apply for a circuit judge position. So it became a 5-way race, and luckily I came out first.
So you went through the election process throughout all of Sarasota County, and I've been through a few election processes myself. That's a little bit tough.
It's very humbling. It's a great experience that everybody should have to go through once.
What year did you take the bench?
Took the bench, well, I was elected in 2002. I started January of 2003.
Tell us a little bit about what a Sarasota County Court judge does on a day-to-day basis and what kind of cases you hear.
Well, county court, we handle, as far as criminal cases, we handle misdemeanors. So any case where the maximum penalty is no more than a year in county jail, county court. It's traffic cases, DUIs, criminal mischiefs, domestic batteries, all those cases where the maximum penalty is up to a year. County court also hears all landlord-tenant cases. We'll hear all civil disputes where the maximum amount in controversy is $15,000 or less. And we'll also hear the small claims cases where one party is suing the other. They can't afford it. They don't want to hire a lawyer. It's the amount in controversy is $5,000 or less, and county court judges hear those as well.
You know, I don't know if people really have an idea of what your workload is as a Sarasota County Court judge, but I can tell you, it's enormous. Could you give us some idea of the numbers of cases you hear on a yearly basis?
On a yearly basis?
Or whatever numbers you might be familiar with.
Well, for example, this week I've handled about 100 cases a day, and some days more, some days less.
When you're handling 100 cases a day, does it run the gamut of what you just discussed with us, or what were you doing this week?
Well, for example, this week I had arraignments where people are accused of crimes. They come to court for the first time and they either enter plea of guilty, not guilty, or no contest. Those individual hearings may take 5 minutes per person at most, maybe a little bit more, maybe a little bit less. I had non-jury trials. Obviously, they'll take a lot longer. I had motion hearings, both in civil court and in criminal court. And I had DUI court that I have once a week. So I have a little bit of everything once a week.
And Judge Denkin, the reason I brought you on the program this month is because I wanted to discuss with you DUI cases and DUI court, because Sarasota County has really shown some innovation in that area. Let's start by talking about the crime of DUI, otherwise known as driving under the influence of alcohol. I think some people have the perception that you have to be severely intoxicated in order to be guilty of that crime. What does Florida law prohibit with respect to driving under the influence?
Well, first off, you don't have to show intoxication as far as the state's obligation. You only have to show impairment. And the way it's read is DUIs can be prosecuted any one of three ways. First, the state has the obligation of showing that the person at the time of driving had a breath test reading above a .08 and at the time and was actually driving or in actual control of the vehicle. The second way to prove DUI is to prove that they were driving, and while driving they were under the influence of alcohol, a controlled substance, or a chemical substance to the extent that their normal faculties were impaired. The third way of proving DUI is to prove that they were driving, and while driving they had a blood alcohol or a breath alcohol content above a .08, which lends to a presumption that they were under the influence.
You know, DUI cases make up an enormous part of the docket of a Sarasota County Court judge. I'm not sure that everybody is familiar with the very serious penalties that are in place under Florida law, even for a first offender. What are some of the typical sanctions or some of the sanctions required under Florida law for a person convicted of driving under the influence?
All right. For a first-time simple driving under the influence, which means it's a driving under the influence, there's no accident, there's no property damage, there's no personal injury, there wasn't somebody under the age of 18 in the vehicle at the time, and the breath test reading was not above a .15. So we call that a simple DUI. There are mandatory sanctions that every county court judge in the state of Florida has to impose, no matter what the facts are, no matter what the mitigating circumstances are. First, you have to be on probation for up to a year. You have to complete a DUI school, which usually runs 3 weeks if you do it on the weekends, and if you do it during the week, you can probably get it done within 2 weeks. You have to attend a victim impact panel, which is a one-day class. You have to pay a minimum fine, and for a first-time DUI, it's $500. Plus court costs, that goes up to about $1,000 total. Your license has to be suspended 6 months to a year for a first-time DUI. And before you can get a work permit, you have to go through some hard time. It's usually 30 days where you can't drive at all. Let's see, what else? Community service work. You have to do a minimum of 50 hours of community service work for a first-time DUI. There's a lot of conditions.
Let's say that a first-time DUI offender comes in front of you, receives probation and some of those conditions, but then doesn't follow the court's order. What kind of sanctions are they possibly facing under those circumstances?
Well, first-time DUI has the maximum penalty associated with it of 6 months. So if you violate probation and the court finds that you violated your probation, in other words, you did it intentionally and had the ability to comply but chose not to do so, then you're facing up to 6 months.
And by 6 months, we're talking Sarasota County Jail.
Yes, we are.
Now, we've been discussing simple DUIs, and you made a point to note that if you didn't have an accident or a blood alcohol level above a .15 or some other circumstances, what happens if you have an accident or some of these special circumstances?
Well, if there's property damage involved, which means if you hit a mailbox or you hit another car, parked or otherwise, it's a first-degree misdemeanor, which means the maximum penalty in jail now is up to a year. All the other sanctions remain just about the same.
All right. So, Judge Denkin, what if somebody comes back, say, within 2 or 3 years' time, and now they have a second offense for a DUI? What type of sanctions are they facing then?
Well, if they get a second DUI arrest within 5 years of a prior conviction, and they're found guilty of the second charge, they're looking at a mandatory minimum jail of 10 days. They're also looking at an increase in the fine, an increase in the license suspension. Now it becomes a 5-year license suspension instead of a 6 months to a year. It's a mandatory ignition interlock device, which means once you're eligible to drive, after you do the 5-year license suspension, you have to put an interlock device on your vehicle that you have to blow into to confirm that you have no alcohol in your system before the ignition will start or the car will continue to drive.
5-year license suspension, that's a pretty severe sanction. What happens if somebody drives even though their license has been suspended for 5 years? What are they possibly facing?
If they get caught, they're facing up to 60 days in the county jail for a first-time violation, and a second-time violation, they're looking up to a year.
And Judge Denkin, do you also deal with people who have had more than 2 DUIs over the course of their life?
More than I care to mention.
So this is ultimately going to lead into the second part of the program where we talk about some of the measures that you're trying to use here in Sarasota County. But if somebody comes in front of you and they have a 3rd or 4th DUI, what are some of the possible sanctions they could be facing then?
Well, it depends, because if it's a 3rd DUI within 10 years, in other words, if you've got 3 DUIs and the 3rd one is within 10 years of the 2nd, they could have been charged as a felony and they go upstairs to circuit court where they're facing 5 years in prison. If they're charged with a 4th DUI or more, that's a felony. Now, the state attorney's office can elect to proceed in county court on those cases, or they can shoot it up to circuit court for felony prosecution. They're looking at more time, they're looking at more mandatory sanctions, including more jail time. So it's 30 days for a mandatory minimum sentence for a 3rd-time DUI with intent.
It's been my experience when I've been in the courtroom that the assistant state attorneys and the court takes these offenses pretty seriously.
I know the state attorney's office does and always has been, and I do as well, and so do the other county judges that are in criminal court.
Well, Judge Denkin, when we return, we're going to talk about some of the root causes of the crime of driving under the influence and some of the strategies that we're using here in Sarasota County to try and address the root cause of the problem.
Works for me.
So please stay with us for some more Law and Sarasota. And we will talk amongst ourselves for a little bit.
Okay.
Show your pride in our schools for only $20 a year. All Apple Tag fees collected in Sarasota County stay here to benefit students through the work of the Education Foundation. Apple Tag funds are invested in the PAL School Volunteer Program. Invest in tomorrow. Buy your Florida Educational Tag today.
Welcome back to Law in Sarasota. I'm your host, Adam Tabrouge, and today I'm with Sarasota County Court Judge David Denkin. Judge Denkin, we've been talking about the crime of driving under the influence. We typically associate that with driving under the influence of alcohol, but those aren't the only type of cases that you see, is that right?
Right. When we get DUI cases, they're either coming into court because they're charged with alcohol consumption, they're charged with chemical substances, such as they're sniffing gasoline or glue, or maybe using canine spice or some other substance, or they're using controlled substances, whether it be pot, cocaine, muscle relaxer, Xanax, anything of those. If you're driving and you're under the influence of any one of those, technically you're a DUI.
What about somebody who's been prescribed medication by their doctor? Is that a defense to the charge of DUI?
It's a defense to having possession of the controlled substance. It's not a defense to driving while under the influence of those controlled substances. Your doctor gave you the authority to carry those and take those. He didn't give you the authority to drive while under the influence of those substances. That's the problem.
Well, you know, Judge Denkin, you and I were both in the court system back in the 1980s when DUI was really attracting a lot of attention in the state of Florida. Sanctions were increased. A lot of strategies have been employed to try and address some of the root causes to driving under the influence, so that hopefully we can reduce the damage that is caused by that crime. Let's talk about some of the methods that are available to you to address somebody's underlying problem.
All right. The first avenue that's available to all county judges is to warehouse them, which means put them in jail as long as we possibly can. All that's going to guarantee is that while they're in jail, they won't be drinking. Every couple years, the legislature has slowly and consistently increased penalties. What the studies have shown throughout the nation is that just increasing the penalties alone really doesn't help. It just doesn't. There's an old saying, it says, the definition of insanity is doing the same thing over and over again and expecting a different result. Well, if I constantly put people in jail and they constantly get out and commit the same crime over again, I got to try something different. So one of the things we started here in Sarasota was about 5 years ago. We started our own DUI court. There's maybe 535 in the nation. There are DUI courts in only 2 other counties, Volusia County, Polk County, and Marion County has a hybrid type of DUI court. But we have 66 counties and we only have, or 67 counties and we only have 3 or 4. So it's a new project. When I say new, it started in 2000. And it's post-adjudication, which that means is that it's not a pretrial diversion program. In other words, you complete the program, the charge gets thrown out or dismissed. You have to admit to the charge because there are certain mandatory sanctions for DUIs that we talked about earlier that you have to impose. It's voluntary. They come to me and say, I want to get into your DUI court program. And we have a little discussion. And before they even get to me, they have to be medically assessed so that they're medically appropriate. Because we test them regularly, a minimum of 3 times a week. So they've made it past the medical assessment. They still want to come into DUI court. And we only accept people that have multiple DUIs in their record. There may be a few exceptions, but generally they've had at least 1 or more prior DUI arrests before I get to see them in DUI court. They come to me and they plead what is known as straight up or an open plea, which means their attorney comes with them to court and says, Judge, we would like our client accepted into the program. There's no guarantee as to what the sentence is going to be. We're just asking that you give us an opportunity to tell you why we think you should accept this person into the program and give him the minimum penalties, for example. I have the prosecutor standing on the other side giving his or her speech saying, Judge, we want 9 months in the county jail plus all the other minimum mandatory sanctions. I listen to the defendant. We discuss how tough the DUI court program is. We discuss the fact that they have to get to court once a week to see me, which in some cases is punishment enough. They have to meet with their counselor. They have to go to group meetings. They have to go to AA meetings. They have to go to random year analysis at least 3 times a week, and it's random. And sometimes on Saturdays. And they have to do everything else throughout the program. It usually takes a year. And I tell them, everybody sitting with you in that program can't drive. So I don't want to hear, I couldn't get a ride, the bus was late, it was raining, my bicycle had a flat, because everybody's got the same excuse. I ask them, you know, it'd be easier, wouldn't it, if you just went to jail and just did the time? 3 months, 4 months, whatever. You don't have to depend upon anybody. You don't have to worry about being responsible. 99 people out of 99 have said, let me go into the program, because they think it's less jail time. That's the reason why they want to get in. And we all know that. Most of them want to get in because it's guaranteed, and I've told them out front, you will get less jail time because I want you into the program because I want to treat the issue, the problem. But if you violate the conditions of the contract, we'll talk about it later on. Some of them come in just for treatment, and I had 3 yesterday that entered into the program. 2 sincerely came into the program because of treatment, because they weren't facing a lot of jail time. 1, I think it was a combination.
Judge Denkin, talk with us about some of the successes of the program and what you attribute those successes to. I've had the opportunity to be on the periphery of DUI court a time or two, and it seems like you have a very dedicated staff associated with DUI court.
We have a great staff. We have 2 counselors, we have a case manager, we have an executive director, we have a probation officer. I have an attorney from the public defender's office, Ms. Drake, and the prosecutor, Spencer Resnick, who are there on a regular basis. And what's most important with the program is that we meet so often. I see them once a week, unless I have to be out of town on a conference or teaching engagement. Counselors see them several times a week. And it's very intensive. We monitor their progress. When they're doing well, they get therapeutic rewards. Everything from gift certificates to bicycles, to free passes to miss a group meeting, to miss court. When they're not doing well, they get what is known as therapeutic consequences. Now, when I tell every one of them, you can either accept the consequence or say, Judge, I had it. I don't think you're being fair. I want out of the program. And then we'll just treat it as a regular violation of probation. I've had 110 plus graduates since the program started 4 years ago. I currently have 50 people in the program. I've had a total of 4 people opt out of the program, 2 of which I've seen and who have thanked me for at least keeping them in the program as long as I have. And the recidivism rate for those people that at least go into the program, not necessarily graduate, but at least go through the program, start the program, is about 4 times less than those people that don't go through the program.
And you know, that's really significant. I think we all have the same goal in the criminal justice system, which is to prevent people from reoffending, if at all possible. I know that this program costs a little bit of extra money up front in order to staff with the folks that you just described, but it seems to me like over the long term, it's really got the potential to save money and save lives.
It saves, when we did the study, because we had to convince both the Sarasota County Commission, the State Attorney's Office, and my Chief Judge that it was a worthwhile program. And I had the help of an attorney that was court counsel at the time, Erica Quartermain. And we had the help of DUI court judges from across the nation, so I got the statistics. And you can't argue against it. It saves money, less jail time, saves money for the Sheriff's Department. It allows for the more serious crimes to be dealt with in jail. It certainly reduces recidivism. and saves lives.
And you and I have both worked with offenders in a variety of capacities, both as attorneys and now you as a judge. But many offenders want to turn their lives around. They don't want to keep ending up in a jail cell charged with DUI. And sometimes they just need that final push or somebody to believe in them in order to make that change.
And that's what's great about the program, because the program also allows them to realize they need to change their environment. That's how you're going to change the behavior. You got to change the environment, and they're surrounded with other people that are doing the same thing they've done, that are trying to improve their lives just like they are, and they help one another. They've helped each other get jobs. I've seen them in court help each other admit to a problem when they just had a lab test that says was positive, and they're looking at me and saying, it wasn't, it's a mistake. And they support one another, and they try to convince each other to do better. And it's a great thing to watch.
Well, Judge Denkin, thank you so much for coming on the program and letting our viewers know about the consequences of driving under the influence and some of the strategies that we're using here in Sarasota County. And thank you for watching another episode of Law and Sarasota.